morning to all my respected brother and sister. Many, many thanks to give me the opportunity to speak on this topic. Last week, our respected Chief Justice of India has mentioned that target of this year for digitization of the file is more than 1 crore. And he has also advised many Chief Justices and Justices who are not savvy to the computer, virtual hearing, and other related matters. And he says that if somebody is not expert, he can join the system and we will help him, and it will definitely work. Today, Justice Sanjay Kishan Kaul of Supreme Court of India has mentioned that end of the day you will find that all the matters will be conducted by virtual hearing. I can give you 2 examples where I was the chairman. Earlier I was the judge of the High Court for about 9 years. Then I was given job for ED, PMLA court for 3 years, and in between I was also given additional charge of IPAB. I can give you the 2 examples that when the new member came in the month of July 2020, 1 member was from Hyderabad, 3 members were from Chennai, and 1 technical member from the Gurgaon, and I was in Delhi. And that was a COVID time, totally restriction by the government of India. And you will be surprised to note all the files were digitized, and on the basis of that modern system and technology, we were able to decide more than 500 appeals in trademark matter and copyright matters, and 200 judgments were delivered by us, me, and Dr. BP Singh, who is sitting here. I am proud of him, and basically he has done a lot in patent, and he has a great experience for 36 years. And I used to talk to Dr. BP Singh that how we can decide patent matters. There were about 800 matters which were pending for years together, more than even some of the matters were 10 years old. He says that, sir, within 6-7 months, we have been able to decide 200 matters. If we will sit like this for another 1 year, we will have 0 pendency before the IPAB. But government has abolished the IPAB and the work has been transferred to the High Court. We have no problem at all. It is for the government to decide. Second example is that when I was a chairman before the IPAB, there were about 50 applications of copyright with regard to the dispute of author and broadcaster. There was a record of 50,000 pages in those matters. There were about 200 matters, and the advocates and solicitors from the entire world, overseas countries, India, and under Section 31 of the Copyright Act, there was a restriction that we must decide the matter by 31st of December, and the cases were filed in the month of July, August 2020. So just see the technology, new era where we have come, and there was a condition under Section 31 of the Copyright Act and under the rule that we must hear all the counsel, public, expert, counsel, clients. And you just appreciate that those matter to be, because the royalty has to be fixed under the statute, otherwise everything will become infructuous. So with the help of this technology, somebody was from Norway, somebody expert was from UK, many advocates from Mumbai, Bangalore, Calcutta, and Delhi, and you will be surprised that we were able to decide all the royalty matters within the period of 3 to 4 months, and we have given the judgment by disposing of 200 matters of copyright. So this is a achievement of the system, and I agree with Justice Call that barring few matters, the time will come that the virtual hearing will prevail upon. It is a golden opportunity for us to use the system. It reduces dependency, it preserves the record, and it is very necessary, because in old time you must have seen that record is summoned from the trial court, and Parveen is vouched for that, because usually I practiced for 28 years. Usually we used to appear against each other for 28 years. And when this technology was not there, scanning system was not there, we used to file the samples in tin box. And many times when to show the sample before the court, many times, sometimes exhibits were not traceable, sometimes that in patent matter, drawing was not available, we were not able, but slowly it has come to scanner, and now this system, digital system, it is a very useful system. Now today we have e-court, e-filing, live streaming of court, legal library, e-inspection, pay of court fee, digital technology, digital signature technology. You will find only 15 days back, our Chief Justice of India has inaugurated the program before the Delhi High Court, where basically e-inspection is allowed. Now there is no need to go to the court. Live file is available for 4 days with you, with the counsel, with the client, with anybody. One has to apply, and all the notes, all the record of the file is available online. The file will be there, live file would be there for 4 days. One can inspect, one can do the system. It is a very helpful move by the court. Now, there are challenging also, because we must say challenging are that some power system failure, people are not versed with, and rural area, a lot of difficulties there, they are not versed with the system. And I am hopeful that if basically we will sit together, we will basically provide them infrastructure, we will have the seminar, we have a judicial academy. Ultimately, end of the day, everything will be cured. And in India, I can tell you, the government can provide any system to help this digital system at any time. Now, one thing basically I will share with you, that is about the private data protection. That is also very important, because when the members were not there, myself and vice chairman were there, we were facing a lot of problem before the IPAB, because somebody has stolen the data, some solicitor from Agra, not in metropolitan city, because they know their job very well. It came to my notice that one of the advocate from Agra, Uttar Pradesh, he was writing letter, person to person client, that I have got so much data. And because data was already digitized of the trademark registry as well as the IPAB. And ultimately I inquired myself, because government contacted me, and there was even the website was closed for 6 months. And I made the inquiry, and it was found that this website operator was mixed up with that council. And you will surprised to note that he was not giving us hard disk. I called him. He says, I will not return. He was demanding so much money from the government, and he was not giving the password. So this basically, I say data protection must be there, and one should be very careful. And end of the day, government then given the order to some government organization, and it went successfully. Now, second chapter is very important, that this system is there, infrastructure is also there, but we all are before the commercial court, and I totally agree with the Controller General that certificate is just a piece of paper, and I totally agree that it is ultimately so much campaign is going on that such and such countries are filing such and such application. We are number 1, we are number 2, we are number 3. But end of the day, we have to enforce those patents. That is basically meant for registration. Otherwise, registration may not be just piece of paper. Now, at the time of enforcement, there are a lot of problems. I will just discuss with you in 2 minutes. And one, basically, I will just say that before the court, I had experience because 28 years I was practicing, 9 years in the court. I always notice that there are 3 types of cases are filed before the court for the purpose of enforcement. One is excellent cases, one is good cases, and one is borderline cases. Now, in borderline cases, trial should be there, or in patent matter, in few matters, trial must be recommended. But where basically excellent cases are there, where good cases are there, where is the question of trial? That is the main hurdle. That is a speed breaker of the case. I say that Supreme Court judgment for the last 70 years in India, our judgments are read all over the world. 70-year judgments are there. It is for the court to decide whether the trademarks are similar or not similar, whether the party is guilty of infringement of copyright or not, whether the piratation is done by under the Design Act. When it is for the court to decide, where is the question of trial in first 2 categories, where the excellent cases are there, when the good cases are there, and under the commercial code, under section 12, the rights are given to the court to decide the matter without trial. Even otherwise, there are 2 provisions in the Code of Civil Procedure that if issue is not arise between the parties, and when there is admission by one of the party, then there is a question of the court straight away pass the judgment in favor of the party. No, the law has gone to that extent that even the Supreme Court has laid down law that even if the crooked person, the person who has deliberately copied, he does not admit that I have infringed the trademarks and copyright, the Supreme Court says, doesn't matter, it is for the court to decide. He may be telling lie. So why basically believe him? You pass the order straight away if somebody has violated the right of the party. Now, experience also show that in a good cases or excellent cases where the ex parte injunction are granted, more than 80% cases are decided on the next date of hearing. Only in those matters, in good matters, where the injunction is not passed, ex parte injunction is not passed, and matter is still pending, despite of that, despite of having good cases. And we must understand, we are dealing with the special act. These are statutory provision is there. If you see under section 135 of the Trademark Act, there is a provision for ex parte. When basically we cannot change the language of the statute. If somebody, because earlier we were dealing with Specific Relief Act, we were dealing with the Evidence Act. Now we are dealing with the Special Act. Special Act says that ex parte injunction should be granted, local commissioner should be appointed. Why not basically court should do it? And you will surprise that before my elevation in 2008, and I retired now in 2021, where the ex parte injunction were not granted in my matter, and I've seen those cases are still pending in my office, although it is done by my other colleagues. So particularly I will tell you about the patent, then basically, because it is a very interesting topic, we must have time to discuss the issues. Otherwise, everything will be futile. We are sitting here, clients are spending a lot of money, and in patent matter, I say the life of the patent is 20 years. Now, under the statute, unless the patent is sealed, no action is maintainable, no common law remedy. So, unless the patent is sealed, there are two layers of opposition. And it has been noticed by me for the last 40 years where there is a successful patent, where there is a valid patent, where the patent is earning something in a country, people are taking full advantage. Full advantage. First opposition is filed under section 25. It is filed by private person. It is filed by company. And then basically all type of objection under the skies are taken. And they are after those patents, particularly where the patent appears to be very successful. And then patent is, if after opposition patent is sealed, then second opposition is also within 1 year per time filed by the same person or through somebody, through their agent or through their own person. So that patent should not basically, should not be protected. Right way or left way, they must oppose. And the third layer is revocation under section 64 of the Patent Act. So basically, and patent is granted by the state, sovereign of state. It's a special right. And these two layers of opposition and one revocation used to take in a good patent more than 15 years, 16 years, lot of. And Dr. BP Singh is here. We are able to decide 200 matters, patent matters, and where basically 16, 17 years are already expired. In few matters, basically even 20-year period is expired. The person just comes, he says, I wish to withdraw the application or I just wish to withdraw the appeal because 20 years is past or my client is not interested now because the patent says no action without sealing of the patent, no passing off, no common law remedy. Now the point here is that if the patent is to be enforced before the court, and Parveen knows it because we used to appear against each other as advocate, that in many cases, patent expired during the pendency of the suit. And ultimately, one person is insisting for damages, and it is hell of the job, I am telling you. Damages is like taking the divorce from the valid wife, So it is very difficult to prove it, So damages is, so why not basically we should hear the patent matter. My perception, because people are going for perception, they are taking the flag of India or something like that. We are not basically worried about all this perception or flag or something like we claim so many things in India and abroad. We are not concerned at all. We should not form any opinion. Doctor is here, Dr. BP Singh is here. Simple point is, in enforcement of patent, that if the patent is valid, if the patent is infringed, injunction must follow. And I always campaign that even in patent matter also, ex parte injunction should be granted in a valid matter. Otherwise, I am telling you, people are creating havoc in a commercial matter where the patent is successful. So we will discuss this issue many times because the time is very limited and it is a very hot topic, and IP matter always basically I welcome. And basically I say that useful protection must be given to the rightful person. Thank you so much. Thank you.